Hello, everybody. Welcome again. Thank you for joining us today. And today we have DJ Jairam with us to talk about guardianship. And just a really brief introduction. I think many of you might already know DJ, but he he does a lot of guardianship work. He also does a lot of Medicaid appeals. And he has been doing this. He's been doing this for a long time. He's very experienced and very knowledgeable on these topics. But I think one of the things that appeals to many of us, because like me, he's also a parent of a child with special healthcare needs. And so that kind of, he kind of understands what we're going through. And just as an introduction, my name is Sitara Nayak, and I work at Parent to Parent of Georgia. And we are a nonprofit, and we serve families of children with disabilities and special healthcare needs. We help you navigate both the special education system as well as the healthcare system. So I don't want to take up any more time. And as I said, please post your questions in the chat as we go along, and I will try to address them as we move through the presentation. And then towards the end, we will have a Q&A session. So DJ, take it away.
Great, thanks for having me. I appreciate the opportunity to talk to you about this very important topic. As you can see, I have my PowerPoint up on the other screen. If you see me looking off to the side here, I'm looking at my slides. This is a two-part series. So today, my plan is to focus on guardianship and what is the process, what are some of the decision-making points you might want to consider, how do you go about choosing a good guardian. And next Tuesday, I'm going to talk about some alternatives to guardianship, supported decision-making, powers of attorney, how they differ, and how you might be able to weigh what's right for your child in choosing between those options. So just a little bit about myself. As Tara said, I'm a parent of a special needs child. He's on the autism spectrum and also has a condition called Williams syndrome. That translates into a very significant intellectual disability. We're on Katie Beckett. We've applied for the now comp waiver. We've had to go through this guardianship decision. He's not 18 yet, but it's definitely something on our horizon. So the reason I like to share that with families is everything I'm going to talk about is something that we're thinking about for my own family. And so to the extent you have questions about how I've come to decisions and how we've set things up, I'm certainly glad to share with you my personal experience. I've been practicing this is an old slide, I've been practicing for 25 years. In addition to my special needs estate planning practice and guardianship, I'm also a judge in Gwinnett County. And so some of the experience I have in guardianship is not just as a parent or as an attorney, but on occasion I see it from the judicial side, where maybe some of the decisions parents have made didn't turn out quite as they expected. And so I can certainly answer questions kind of from that side, how the judicial side may look at things. Okay, just a disclaimer I have to say, this is general legal advice, not specific to your situation. As I hope I make clear as we go through this, there is no right answer to whether guardianship or the alternatives are right for your family. It's whatever is the right answer for your family. There is no universal right answer to any of these things. But if you have questions about your specific legal issue, please feel free to call me, email me, contact another attorney that does this kind of work, and they can talk about the specifics of your situation. This is my son, Kai. I always like to put a slide in there of him, just because he is the reason that I do what I do. Okay, so what are we going to talk about? We're going to start with the basics. What is guardianship? 2, the legal and practical standards for getting it. How do you go about getting it? What's the legal standard you have to meet? And what are some practical decision-making items that you may want to think about in deciding whether guardianship is right for you or not? 3, if you do decide to go down the guardianship path, how do you choose a good guardian? One of the hardest things I see in my practice is you'll occasionally see well-meaning guardians stepping into a parent's shoes, if that's what's happening, who are not necessarily well prepared to fill those shoes. So how do we get them well prepared? And last, if the guardianship process is right for you, how do you get it? What are the steps? What are the things you need to do? So those are the 4 things I hope to cover this evening. So let's start off with the basics. What is a guardian? So a guardian has final decision-making authority over somebody called the ward on specific subjects. So there's a difference, and we'll talk about that on the next slide, of guardianship over a minor, that's somebody under the age of 18, versus guardianship for an adult who's 18 or older. And I'll talk about that on the next slide. But one of the things that a lot of people get confused, or I get a lot of questions about, is the difference between guardianship and conservatorship. A lot of people think conservatorship is an alternative to guardianship, and that's not quite right. Guardianship and conservatorship are kind of 2 sides of a coin. So with guardianship, a court is determining that somebody cannot make decisions, whether because they're a minor or because they meet a legal standard for an adult. That person can't make decisions about what's in their best interest on certain topics. So the guardian is over the individual's legal rights and their personal safety and well-being. A conservator is in control of that person's money and assets. So conservator is money and assets. Guardian is the person and their well-being. Just one quick note on the side. You have to be careful with conservatorship. If you go through the process, the paperwork for conservatorship is tied into the paperwork for guardianship. But if your child is getting SSI or Medicaid, a conservatorship is considered that child's assets. So anything in a conservatorship, you could potentially lose SSI benefits. For a, you might want to think about special needs trust in that situation, but just a heads up if you're considering conservatorship along with guardianship. So who needs a guardian? Like I was saying, all minors, anyone under the age of 18 in Georgia has a guardian. It's their parents. Now you do want to choose successor guardians if something happens to the parents, if they pass away, who's going to step into their shoes to look out for that minor, special needs or not. The other people who need guardianship are adults. Now, the only way to get guardianship over someone who's 18 or older in Georgia is to go through the legal process with your local county probate court to get guardianship awarded, okay? So court is the only entity that can determine guardianship, okay? Now, that's true if you're the parent too. So just to be clear, when your child is going from 17 to 18, you want to start thinking about this, whether guardianship is right for your family or not. So if your child turns 18 and you've determined guardianship is the right choice for you and your family, you want to get that guardianship process going. It is not something that happens automatically. Even if you're the parent, you have to go through that legal process. So just kind of keep that in mind. One of the main questions I get all the time is the difference between guardianship and powers of attorney. I'm going to talk about that in the next session, or I can answer it during the Q&A, but this presentation is going to be more focused on the guardianship piece. When do you start the process for guardianship? When do you start thinking about it? When do you start weighing that against powers of attorney and supporting decision-making? I always suggest 17 and a half is the right time to start. That gives you several months to gather your documents, to talk to professionals, to talk to other parents, decide which option is right for you. And then if you do decide to eventually go down the guardianship route, you're prepared to file that paperwork and get whatever you need in place as your child turns 18. So there's no gap in that decision-making legal process, whether you're helping them or someone else is helping them with that. So now that we know who needs a guardian, what is the legal standard for guardianship? And so I've got the standard up here on the screen. The statute, if you care to look at it yourself, is OCGA 29-4-1. And what it says, and I like quoting from the statute because this is the legal standard. This is what the court will look at in determining if guardianship is right for your adult child. And the court may appoint a guardian for an adult only if the court finds the adult lacks sufficient capacity to make or communicate significant responsible decisions about his or her health or safety. Now, a couple of things about this definition I want to draw your attention to. One, it's do they lack the capacity to make that decision? Not will they make good or bad decisions. So if you liken that to, say, an 18-year-old who does not have special needs versus an 18-year-old who has special needs, well, the 18-year-old without special needs may make bad decisions, but they have the capacity to make them. With a special needs individual, we need to focus a little bit on, can they even assess the factors that go into making a decision on their health or safety? Okay. So the second thing I want to draw to your attention on this is the ability to communicate that responsible decision. We have a lot of people who have cerebral palsy or strokes or something along those lines, where they may be limited in their ability to communicate that decision, but they have the capacity to make it. And notice in the definition, it says or, capacity to make or communicate. So it's different now. You got to remember, the standard was written many years ago. We have communication devices now. We have iPads. We have software in our laptops that allow people to communicate now when they may not have been able to communicate several years ago. And so it's just something to look at there, that if your child's ability to communicate is compromised, but intellectually they can still make those decisions, you still may be able to qualify for guardianship if that's your choice. So this is the legal standard you would have to meet to get guardianship over an adult, 18 or older. This is the legal standard for which you have to present evidence to that court, whether documents, whether testimony from you, telling the judge why you meet this particular legal standard. So I never found the legal standard to be particularly helpful in making the decision. So a lot of things I would tell my clients or I would share with them in helping them make that decision is you have to look at some practical decision-making standards. So there are a couple things that I like to point to that may not jump out at you. So a little bit later, I'm going to go through the rights that are taken away from your adult child when they turn 18 that are then revested with the parents. What rights are removed from them and given back to the parents in the guardianship process? One of the main rights for day-to-day concerns that I hear from my clients is the ability to enter into a contract. If you have guardianship over an adult, the right for that adult to enter into a contract has been removed from them and placed with you or whoever the guardian is. Do you want your child to be able to enter into a contract? Do they have the ability to understand what a contract is? That there's an obligation on both sides to perform in a certain way? Do they understand that it's legally binding? And if they don't follow that contract, there are consequences. They don't have to understand every little legal clause in that contract, but do they understand the overall concepts? For me as a parent, that's not one of the number one things I think about in terms of protecting my child from people who want to take advantage of him. If he is able to get a job, is able to earn some money or save or buy things, can he be taken advantage of? So here's something to think about. I'll give you an example. One of my colleagues had told me about from one of her clients, and that's the credit card example. And so this happened many years ago when credit card companies would call you at home and they would ask if you wanted credit cards. Well, this particular family had a very high functioning adult child on the autism spectrum. And that adult child answered the phone, and it was the telemarketer saying, hey, do you want a card? No payments for a year. It's basically free money. And so the adult child said yes. Well, the credit card came in. The adult child's one of the chores was to get the mail from the mailbox. He got the card, and guess what happened? All of a sudden, he had friends he never had the week before he got the credit card. In 1 month, he ran that credit card up to the limit. Now, what happens in that case? Well, the bill came in, the parents saw it, they called the credit card company and said, look, he has autism, he has an IEP, we have a diagnosis, what can we do about this? Well, the credit card company's answer was, we're very sorry about that, when are we getting our money? Well, so what does the family do? Well, in that situation, if guardianship is not in place, that contract is presumed to be valid, so that they will owe that money. Unless you go to court and you can prove to a judge that your child lacks capacity to enter into that. Well, the credit card was $3,000. It was run up to $3,000. You know the credit card company is going to have a lawyer. Is this family going to have to hire a lawyer? Probably. Is the lawyer going to cost more than $3,000? Probably. So you see how that's a difficult situation for the family. In a situation of guardianship, that right has already been removed and adjudicated, removed by a court. And so that contract is void from inception, like it never existed. And so that's a real life example. And so we do see that on occasion, people who will come in, clients who will call me. Occasionally I see it in court in my judicial capacity of people who just had no idea what they were signing. And not because they lacked they didn't take the time to look at it, because they lacked the ability to even understand it. And so it's just something to think about as you go through that decision-making process. There are several other big differences. I'll talk about that when we get to the rights that are removed from the individual, and a couple other things you may want to think about in making this decision. So here are those rights. Number one is the ability to get married. If you get guardianship, the ability to get married is removed from the individual. Number two, the ability to make or modify or terminate contracts. Like I had said before in the earlier slide, that ability is removed. The ability to consent to medical treatment. The ability to decide where you're going to live and establish legal residency in one county or one state. The ability to revoke a trust if that's in place. And the last one, this is a legal language, but really what it's saying is the ability to exercise your legal rights as an adult in Georgia. All of these rights are removed from the ward and given back to the guardian. And the guardian exercises these rights on behalf of the individual. Okay, so if you decide guardianship is right for you and you go through that process, and I'm going to talk about the exact process a little bit later, that's great. Many times it's the parents that are put in place, but how do you go about choosing your successor guardians? Who comes after us? Who comes after the parents? Very important in your estate planning when you're developing a will or a special needs trust. You're going to want to have a really good discussion with your attorney about guardianship and what you're looking for. So once you're in place, that's great. If you want to choose a successor guardian, you don't choose it during the guardianship process. That's not where you make the choice. That's not allowed in Georgia. You choose your successor guardians, the people who come after you in your estate planning documents, in your will, in your trusts. That's where you're going to make that decision. Couple things to consider when choosing the people who come after you. How old are they? How old are those people? Do they have the energy to do what needs to be done? I get this one a lot. I get clients who will come to me and say, look, my grandparents know my kids really well. They visit all the time. I want them as guardian. I said, okay, well, how old are they? Well, they're in their mid 70s or 80. You know, that's hard. That's a hard ask. We know, all of us who are special needs parents listening to this, we know how much energy it takes. We know how stressful it is. Are they going to have the ability to do that? How is their health or the health of their spouse, right? If they're going to end up having a poor health condition themselves or having to care for a spouse who has a health condition, are they going to have the time to do what needs to be done for your child? Do they have an established relationship with your child? Another one thing I see a lot of, people will say, well, this is my sister. She's the person I trust the most, but they live in Texas. Well, my next question to that client is, how often does the sister see your child? Well, you know, around the holidays and maybe once in the summer, a couple of times a year. Well, is that enough of a relationship? For special needs parents whose kids will need guardians throughout their life, like my son, this is really important because these are functional documents. It's not a question of whether those successor guardians will step in at some point. It's when will they step in. And so when you choose those people, I would suggest you want your child going to someone who they know and love, or at least have a relationship with, not somebody they've only met a handful of times. Now, again, there's no right answer, but that is something I do want my clients to think about. How do they handle stress? Right? Being a special needs parent is stressful. You spend a beautiful spring day listening to a lawyer on Zoom instead of out there enjoying the weather. It's hard. There are sacrifices. Services. What services are they getting? I know Parent to Parent gives some great presentations about the Nile and Comp waiver. That is a hard waiver to get. You all know about the waiting list. If you have those very valuable services, if you choose a guardian out of state, is your child going to lose those benefits? Well, it depends. Is your adult child going to move to live with that guardian out of state? If they do, they're going to lose the Now Comp waiver. If the guardian is going to be out of state, but your child is going to stay in Georgia, they may be able to keep it, but we have to think about it. And the more thinking we do, the better guardian choices we have. Friends. You know, one of the hardest things for our kids to do is make friends. And hopefully they all have at least one, or hopefully more than that. If your guardian choice lives not in your area, and your expectation is the child to go live with the guardian elsewhere, are they going to lose those friends? Are they going to lose, the house they lived in, the room they lived in, their yard, their neighbors? Maybe, but we have to ask all these questions to get to the very, very best decisions we can for our successor guardians. The way I suggest people address this is, if you're having trouble making that decision, most people do. This is where they get stuck on guardians and then trustees. One is make a list of the strengths and weaknesses of your guardians. Age, location, how many kids do they have, health situation, financial situation. Just make a list of all the things you like or maybe don't like quite as much about each of your potential guardians. You've got to accept you will not find your clone. I mean, we all say that. I hear this all the time. We have to live forever. My wife and I say that all the time. Until they come up with that technology, we're going to have to pick the next best thing. Look at the next 3 to 5 years in making this decision. Basically think, look, if something happens to me in the next 3 to 5 years, this is who I want. This is who I want as guardian. If you really start thinking way, way, way into the future, the decision-making becomes unmanageable. And so put something in place, make a decision, have that protection in place, understanding that you can change it whenever you need to. Tell yourself you have to hire in air quotes. You have to choose someone for the most important job in the world, which is raising your child or looking out for your child. If you don't make that guardianship decision for you and your family and your child, someone else is going to make it for you, either a judge, a court, somebody else is going to make it for you. So please make this decision for yourself. You absolutely have to make it if your child's a minor. If your child is approaching adulthood or in adulthood and needs a guardian, you absolutely need to make it. If you don't know if they will need a guardian once you're gone, make it. Because if they don't need a guardian after that, the fact that you've chosen one is not going to have any impact, that they don't meet the legal standard. So always err on the side of making this decision than not making it. Okay, how do you have a conversation with the guardian about these really important things? So you've gone through the list, you're like, this is my dream team. I always suggest 3 successor guardians, 1, 2, 3. The greater age difference you have between them all, the longer lasting your decisions will be. So say your primary is 50, you want your backup to be 40, your backup to that to be 30, and so forth. Once you've identified those people, talk to them about it. Be honest about your life. Tell them what your day-to-day is like. You don't want them to be surprised if they have to step into your shoes. You want them to step into your shoes knowing they can do the job, and they know what the job is, okay? This is not the time to worry about hurting anybody's feelings. I get that one a lot too. Well, you know, I think my siblings or my parents will be hurt if I choose my friend as the guardian. You know, you got to make the best choice for your child. And so don't worry about hurting other people's feelings. Give them time to think about it. Don't, you know, you can tell them about your day. If they have a partner or a spouse, give them time to talk to their spouse and partner about it. It's kind of a big decision, especially if you know your child is going to need a guardian after you're gone. And then ultimately, I always suggest, let them say no. You know, sometimes people are afraid to say no because it makes them sound like a jerk. You know, here is this friend or family member asking me to care for their special needs child when they're gone. I can't say no. That's going to sound terrible. You want them to say no if they can't do the job. You only want them to say yes if they are able and willing to do it, okay? So I say, look, you know, feel free to say no. I'm going to talk about this important thing. It's not going to affect our relationship. Now, that's not necessarily true, but that is what I tell them. Okay? But you do want them to say no if you think they can't do the job. Once you have your guardians in place, how do you prepare them to succeed? Many of you have heard of something called a letter of intent. I call it a letter to your guardians. Basically, we have to pass on our accumulated knowledge about our child to these guardians so they know what to do if they step into your shoes. This is really important if your child has a communication issue, intellectual disability, anything like that, or just by virtue of being young. What makes them happy or sad? Tips on taking medicine. Do they fight you on that? Is there a bedtime process? Is there a feeding process? Is there a favorite show or toy? Who are the healthcare providers? Who are the therapists? Who are the specialists? We spend years putting these people together. We have to let guardians know who these people are. Where are your assets? Is everything you need financially to take care of the child? And so I can tell you how critical this is. We all come up with tips and tricks throughout our lives to just get through the day. And, I always like to share one. The references on this slide are a little outdated. I'm going to tell you a new one. So my son has communication issues. He's what we call semi-verbal. He has phrases and some words, but he has a lot of trouble communicating, has a pretty significant intellectual disability. If he wants me to chase him around the house with his stuffed toy, he'll say, "Daddy, done." Well, what is that? What does that mean? And of course, you're not going to know what that means because it's not clear. It's not intuitive. And so I have to tell the guardian that if they come to you and say, "Melissa, done," this is what it means. And so in case you're wondering what it means is my son's stuffed animal, it's a little killer whale. He doesn't know the difference between a killer whale and a shark, so he calls it a shark. Well, when I chase him with his shark, I do the Jaws theme when I chase him around, dun-na, 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 and I chase him around the house. So that's what he relates to playing with me chasing him with that stuffed killer whale. He says, "Daddy, done." I have to give that information to the guardian. If I don't, and something happens to me suddenly, and my son goes and asks the guardian, "Melissa, Dunna," and she has no idea what he's talking about, there are two really bad things I've done. One, I've stolen his voice, which, I just can't live with. Two is I've taken away something that he enjoys that he might be using as a coping mechanism because he knows mom and dad aren't there. So whatever it is, bedtime process, feeding, bathing, diaper changing, sensory overload, whatever your processes are, making sure they don't watch too much iPad or monitor what they're watching on the iPad. You've got to pass this on somehow, whether by letter, whether by video, by email, whatever it is, you have to ensure this information gets to your guardian one way or the other. Okay. Number one question I get: what if we can't find anyone? And the really unsatisfying answer I give my clients is you have to find someone. Because if you don't find someone, there are really limited options. Will the state step in? Will the county step in? Yes. There are county guardians. There are public guardians out there. I would suggest they are not the best option and are not going to pay the attention to your child that you would want to be paid. And so you do want to find someone. Expand the search. If you can't find it in your immediate family, look to extended family. If you can't find it in immediate or extended, look to friends. If you can't find it in that, look to support groups. Look to other special needs families that may be having the same challenge. But again, if you don't make the decision, a judge is going to make it for you. And there's no way that judge knows all the players the way you know all the players. So you will make a better decision than any judge ever will. So we have to do that. There are professionals, most of the attorneys I know who work in the estate planning, special needs estate planning field, including my firm, can help you talk through the choices and help you identify people if you're struggling with that. Okay, so we've gone through what is guardianship, who needs it, how do you pick a good one, what the legal standard is, and what are some of the practical standards. So let's talk about the process. If you have decided guardianship is right for your family, and again, I'm going to talk about alternatives next Tuesday. But if you decided that guardianship is right for your family, what is the process? So here's the overview of the process. I'm going to go in greater detail into all of these things in just a minute. Number one is you have to file what's called a petition for adult guardianship with your county probate court. You can get that petition online. I'm going to give you that link. There is a cost that you have to pay into the court to get the guardianship process moving. There's a way to waive that fee, so I'll talk to you about that. You have to choose a provider, a healthcare provider who's going to examine your child and report back to the court. There's certain notices you have to give out when you file the petition. You have to let certain people know. And again, I'm going to go through all of this in detail. Once you file the petition, the court will review it. And if there's enough evidence, a much lower standard of evidence to proceed with the guardianship process, they will appoint an attorney for your child. The court will also appoint a psychologist or a social worker to examine your child and then file a report with the probate court on whether your child meets the legal standard or not. Now, who this psychologist or social worker or physician is depends on where you live in the state. So in the metro counties, what we generally see is that the court will make an appointment for you, or they will give you the name of the professional who's going to review your child. And then the professional sends the report directly to the court. Outside of Metro Atlanta, what we generally see are those probate courts will allow you to choose the professional. So it could be a psychologist or a social worker or a pediatrician or a psychiatrist who's seen your child, and you can make the appointment, have that professional fill out the paperwork and send it directly to the court. Unfortunately, every county in Georgia does things a little bit differently. So we'll talk about how you deal with that fact in a moment. At the end of that process, there will be a hearing. You're going to end up in court in front of a probate judge presenting evidence on whether your child meets the legal standard for guardianship or not. Now, the level of formality of that hearing depends on the county you're. All the metro counties, you end up in a courtroom. The judge is on the bench in a robe. You know, you're sitting at counsel table. It's kind of a full hearing in a very formal setting. In a lot of the non-metro counties, it takes place in a conference room. And the last, Ashley with my firm does a lot of our guardianship work. The last one I did outside of Metro, the judge came in a golf shirt and shorts and just kind of, you know, it was on the record. There was a court reporter and just kind of chatted with us, chatted with the ward, chatted with the parents, said he had enough. So it's going to differ where you are. The need for an attorney, this is the big one I get. Do I need a lawyer to get guardianship? The answer is generally no. You don't need a lawyer to get guardianship, okay? Probate courts are generally geared towards helping families through that process. Now, there are some exceptions to that. One is it a contested guardianship? Is it opposed? Now, that opposition can, where we generally see it come from, we can see it come from if the parents are no longer together. Sometimes we'll see one parent say yes to guardianship, but the other parent saying no. So if there's someone out there willing to oppose guardianship, you now have a contested case. The other time we see contested cases or opposed guardianships is when the ward themselves, the adult child says, I don't want it. I don't want guardianship. They hear about the rights that may be taken away, and sometimes it scares them. and they say they don't want that. Now, here's where you go back to something really important. That attorney I had mentioned on this, I don't know where I put him. This attorney up here who's appointed for your child. Here's the thing to remember about them. They're an appointed attorney for your child. Their job is to represent your child and whatever your child wants, not what is in the best interest of your child. Okay, so if your child tells them they want to oppose guardianship, they don't want it, it's that lawyer's job to oppose guardianship. Now, there are other attorneys that are sometimes involved in the process called guardians ad litem. And those, if those are attorneys, their job is to kind of assess the case and report back to the court on what is in the best interest of the child. But sometimes if the child says they don't want guardianship, they have an attorney who's opposing that petition, you're going to have a hard decision. Are you going to fight that fight with your child on the other side? Or are you going to do something else? If you're going to fight that fight, I would suggest that you probably would need an attorney in that situation. The other time you would probably want an attorney is if you have a very high functioning child, but you still think guardianship is the right choice. The higher functioning the child, the less likely they are to meet the legal standard I shared earlier in the presentation. Well, that's because maybe they can make those decisions. Maybe they can communicate those decisions. So the higher functioning you are, the closer to the standard you are, that you're not going to meet it, you may want to consider having an attorney in that situation. But anything else, if your child, has a significant intellectual disability, significant communication disability, significant physical disabilities, they're always, something that's more clear to the court, you generally do not need a lawyer to help you through this process. So let's talk about the steps in getting guardianship. The first thing to know are the definitions. Satara, can you remind me how much time do I have?
We are 6:45. So about 50. We have till 7:15.
7:15. Okay.
Yeah.
Thanks. So quick, the definitions. As you read through the petition, you're going to see some of these definitions, so it's good to know. The proposed ward would be your adult child, the person you're seeking guardianship over. The petitioners are the people who are trying to get guardianship over the proposed ward. It's normally the parents, but it can be anyone. Anyone can seek guardianship over anybody else, but you need two of them. And we do suggest that it be two people who know your child, not you and a professional. That's an option, but generally it's better to have two people who know your child being the petitioners for guardianship. I already explained what guardianship and conservatorship were. Again, the guardians over the physical well-being of the ward, the conservators over their property and their financial matters. Step two is you want to gather all of your documents. So where do you find the petition? The actual document you have to file with that probate court. You find it at this website, gaprobate.gov. Once you get on there, at the very top ribbon, you'll see standard forms. Click on that, and there'll be a long list of standard forms. What you want to look for is form number 12, which is the petition for appointment of guardian/conservator. That is the petition you will file with the court. We do suggest that when you do that initial filing, you physically go down to your local probate court and file it in person. A lot of counties have additional paperwork they want you to file. They'll have a little bit extra application or a one-pager for contact information. Whatever it is, every county may have something a little bit different. It's much easier just to go down to the probate court and file it than to file electronically and or by mail and have it returned to you. One of the documents that, I'm going to talk about this down here, but one of the other benefits of filing in person is there is a way to waive the court fees for filing the guardianship petition. It is much better to go to the clerk of the court where you filed the petition and ask them in person, what is the process? What is the paperwork? It just goes a long way to put a face to that petition in some of the counties, how they help people get those fees waived. Besides the petition, you probably want at least a recent IEP. If you have one, you don't have to go out and get one. Or a recent psych eval, if you have one. Again, if you don't have to go out and get one, but if you do, it might be something worth attaching to the guardianship petition. Step 3, after you pulled all that together, you filled out the petition. Go ask your probate court clerk some questions. Like I said before, these clerks, the probate courts, are used to helping people without attorneys. Your success may vary. So just to be clear, depending on what county you're in, see, Fulton's been kind of difficult sometimes to get answers. Some of the smaller counties tend to be a lot more user-friendly. But you can ask them questions. Some of the questions you may want to ask them is, do you need an attorney? Some counties really encourage it. Others will say no. If they are saying absolutely with this judge, you need an attorney, I would listen to them. Ask them what the filing fee is. Every county handles filing fees differently. Some metro counties will say, look, you pay $600 up front and you're done. Nothing else. Others will say $150 up front, but then we're going to bill you for certain things as we go. Just ask them so there are no surprises and you can budget for what you need to. How can you submit the fee? Some counties want a money order or a personal check. Some of them will not take credit cards, others will. So ask. Where do you send the petition? You know, if you live further out from the probate and you want to mail it, that's fine. But like I said, we do suggest you do the initial filing in person. Ask them if the fees for the appointed attorney, the attorney who's appointed for your child, ask if those are in addition to the filing fee or if they're included in the filing, because that can be a significant amount. Finally, ask whether you need to make that evaluation appointment with the social worker, the psychologist, the medical doctor, the psychiatrist, whether you need to make that evaluation appointment or will the court clerk do it for you. And every county handles it different. So make sure you ask your clerk. Like I said, for families who cannot afford the fee, the counties have procedures where the fee can be reduced or eliminated, but you have to ask them for that. So just ask them, look, is there a way that the fee can be waived or reduced? They're going to give you some paperwork to fill it out and hand it back to them. And again, it always helps to put a face to the application. So that's why we encourage you to do it in person. All right, once you get the petition pulled together, you got your documents put together. If you're handling the petition yourself, you're doing the drafting, go slow, take your time and fill everything out, even if you're not sure that you should be filling it. The only thing you want to be careful with is there's a section of that petition which will ask you about conservatorship, whether you want it or not. Just make sure, again, you understand conservatorship, anything in that is your child's asset for SSI purposes. So just be careful if you do get conservatorship that you're aware of that. 2, you're going to need those 2 petitioners. Now, can one of those petitioners be a medical professional? The answer is yes. Courts don't like to see it. They generally want the petitioners to be 2 people who know your child. 3 in the petition is you're going to have to list people to notify about this guardianship process. You're going to give them legal service of notice that this is going on. And there's a certain priority in which you have to name these people. So for example, if it say the parents are not together, one parent's filing for guardianship, you absolutely have to let the other biological parent or adopted parent know about the process. You can't do it without notifying. The statute and the rules give you a certain priority of at least two people you have to notify: parents, siblings, grandparents, and uncles, and you kind of work your way down with cousins, friends. But you want to start identifying two people close to your child who can do those things, who you can give notice to. The most important part of the petition is called the statement of fact. All that is you explaining to the judge in your words why your child meets the legal standard for guardianship. Why do they need a guardian? They give you about this much space to write in. It's never enough. You can always put in there "see attached," and then you can add a separate page where you write out your statement of fact. Make sure you title it "statement of fact" on that extra sheet, and type it. Do not handwrite it. One of the pet peeves for every judge I've ever met, myself included, is if you get something, you're spending your time trying to read it, but you can't figure out what it says. So type it, please. Step 5, like I said, you file the petition. We suggest you go in person to do that. You want to take 2 copies down to the courthouse, one that you give them, that's the file copy. And you're going to want a copy for yourself that they can stamp for, okay, as received. Make sure you have the filing fee. So you've called the probate court ahead of time to ask about the filing fee. Is it check? Is it money order? Is it credit card? Since you've asked them before, you're going to go down with the petition with that fee ready to go. After you file that petition, that's where the service of process happens. So my clients are never comfortable understanding this, but guardianship is a lawsuit. You're basically suing to take away somebody's rights. And so that person, the proposed ward, has to be served with that petition. Now, again, different counties will handle it different ways. I know in Gwinnett, can happen any number of ways. Gwinnett, where I live, the sheriff's department can go out to the house and serve your child. Some of the kids think that is the coolest thing in the world. You know, they know when they're coming, and it's kind of an exciting day for them. Others get nervous when a stranger will come up to them. And so you can always ask the probate court, is it possible for us to come down to the courthouse, to the sheriff's department, and we can pick up the service copy with my son? So you can always ask that. The court, once the petition is filed, the court will review it. What they are looking is for a standard called probable cause, which is amongst the lowest legal standards. They just want to make sure there's enough to go through the rest of the process. If they find probable cause, that's when they will appoint the attorney. That attorney may or may not meet with your child. In Gwinnett, they meet with your child. In other county, in Forsyth, they meet with your child. In other counties, everything's done by email or phone. So that attorney may or may not meet with your child, but they will be appointed. If the court does find probable cause, it's going to issue an order for 2 very important dates. One is that doctor's evaluation we talked about. And again, are you choosing that evaluator, or is the court choosing? You're going to ask the probate court. And after that evaluation is done and that doctor or psychologist or social worker has returned the paperwork to the court will set a hearing date. And that is the date where you will go and present evidence to the court on why your child meets the standard. When you're at the hearing, you're going to appear in front of the probate judge in your county. and you're going to testify. Basically, you're going to testify to what's in your statement of fact. This is why we meet the legal standard, and this is why my child needs a guardian. Again, the level of formality varies from county to county. You can get the judge in the robe, you can get the judge in the golf polo. It just depends on your county. Again, you prepare your testimony based on your statement of fact. It always helps for know what the legal standard is. I've provided it to you, I've given you the citation. Just understand what the legal standard is, because as long as you tie everything you're saying back to that legal standard, the judge is going to know you've done your homework. You always start with my child meets the legal standard because, okay? Because you have to tie the facts back to the law. Always be polite to either side, whether it's the opposing attorney, whether it's the court reporter, whether it's the judge, just be polite. Always address the judge as your honor, or sir, or ma'am, but just you need to show due respect to the court. And finally, do not get frustrated. You know, the court only knows what's in the petition and some of the paperwork. They don't know your child yet. Don't get frustrated. What's obvious to us as parents about our child's challenges or lack thereof may not be obvious to the judge. So just be patient. Be patient with them if they ask you to repeat things. During the hearing, if you don't want your child to be there during the hearing, you can ask the court-appointed attorney to waive their presence. You can do that. That court-appointed attorney is the only person who can waive your child's presence. You can't do it. Only that attorney can do it. If it's very clear your child meets the standard, most attorneys do and say, look, your child doesn't have to come. Sometimes the court wants to put eyes on the child. And so if you want your child to come to be part of the process, or the opposing counsel doesn't agree to it, or the court wants the child there, one thing you can do is just introduce your child to the court at the beginning of the process. The attorney will usually do that. But you can ask the judge, is it, oh, now that you've seen my child, is it okay if they wait outside with their other parent or friend or sibling while I testify? A lot of parents don't want their kids to hear about their child's challenges or liabilities from the parent. You know, as parents, we're used to kind of telling our kids, you can do it, you can do it, you can do it. And now we're in court saying they can't do it. So sometimes it's better just to say, now that you've met my child, is it okay if they wait outside? Every judge I've ever met is okay with that. The court's satisfied just having met the child. After you testify, the attorney on the other side for your child will ask you questions. Sometimes it's in support of your petition when they aren't really opposing anything. And the judge almost always asks some questions too when things are unclear to them. They'll ask some additional questions. At the end of the hearing, the judge will generally decide right then and there whether you've met the legal standard for guardianship, and then give you instructions on kind of what comes next, taking the oath, filing paperwork as time goes on. They'll instruct you about all of that. Real quick, I know this is recorded, so you can have access, just a couple of the relevant statutes. If you just Google any of this, it's going to come up. Start with OCGA and these numbers. But 29401 that's where you're going to find the legal standard. 29410 is kind of what needs to go in the petition. You don't really need that so much because you'll have the petition itself. What do they need to find probable cause? And the evaluation report from the physician is down here at 29412. You don't really need these, but in case you want to go do your own research, those are great places to start. That is the presentation. I had to fit a lot into an hour. I am glad to take any questions if anyone has any.
Okay, thank you so much, DJ. What I'm going to do is I'm just going to stop the recording now, and then people can, I have a few questions in the chat that also I can ask. So bear with me 1 second as I stop the recording.